हाँ जी दोस्तों, क्या हाल है, क्या हाल है, क्या हाल है। आई होप यू आर ऑल डूइंग रियली रियली वेल.
How are you, students? Tell me, how are you all doing? Students, quickly tell me in the comments. How much enthusiasm do you have? Quickly tell me, how are you on the chat? I am waiting. Okay, students. Now we are going to start. Someone commented good night. So, students, now we are going to start the CA final revision marathon. And I am going to teach you the first chapter, which is appointment and qualification of directors. Students, if you guys are excited for this marathon, make sure you like the video and tell all of your friends that the fully amended video is coming soon on this channel. Okay. And make sure to subscribe to the channel so that you guys don't miss any notifications. Where can you get these notes? These are the fully amended notes. You can get them in the description below. If you order them now, those notes will be in new notes that you will get. But if you have any old edition, so don't worry, I have uploaded the video of all the amendments on YouTube. Just go to the playlist, find see a final paper for amendments, and your work will be done. Without any delay, let's start with today's lecture. We will do chapter 1 as I told you. Without delay, let's start appointment and qualification of board of directors. Promise me that you won't get up and leave until this chapter is over. I promise you I will finish your entire revision in 1 hour and 5 minutes. And not single thing will be missed. This is my guarantee. Okay. We will do revision from exam POV, but it will be little fast, I guarantee you. And this is the speed that you'll need for the day of the exam. Don't get worried about the speed, whether fast or slow. Here, firstly, you can revise it if you feel like you are going too slow. Otherwise, watch it on 0.75x. But students, it will be really fun when you watch this video at 1.5x speed. Listen to me. Let's start Board of Directors chapter. So the first question in this chapter is, what is need for Board of Directors? There are 3 reasons why company needs Board of Directors. First, company is an artificial person. The company has a huge number of shareholders. All shareholders cannot run company. And thirdly, section 149 says to have board of directors, so they should be there. We will follow what section 149 says. Then I told you that the director who is there, who is he? He can also be an agent and a trustee also. Why is he an agent? You will ask, where did this whole syllabus come from? It is in ICI module in syllabus. There is nothing outside it. I said the agent and trustee. Why is it agent? It is called agent because the director works like an agent. Whatever work the director does, company will be bound by it. Okay. And secondly, trustee. Why do you call it trustee? Because they are responsible for taking care of the company's assets, properties, and other things. Did you understand? I hope you understood. Now we will start section 149, which is relevant from exam POV. Subsection 1 says company to have board of directors. So only who can be there in board of directors? Individual. No corporate firm will be there, only individuals will be there. Minimum 3 director, 2 director, and 1 director. Minimum 3 in a public company, 2 in private company, and 1 in one person company. What is the maximum? The maximum will be 15 directors. Sir, can we have more than 15? Yes, of course, but you will need to get SR passed. But sir, this maximum of 15 directors and the SR provision, this will not apply to government companies. And section 8 companies, the condition is that they have complied with sections 92 and 137. They have complied with sections 92 and 137. Apart from that, if the articles of association want, they can set a lower limit for the maximum number of directors. Means AOA can say, in our company, the maximum won't be 15, it will be 12 or 10. They can also specify a lower limit. But can AOA say this, that in my company, maximum will be 20 directors, not just 12 directors? No, the law has stated the maximum. The law has stated a maximum of 15. So you can't say more than that, you can say less than that. After that, they said that some prescribed class of companies need to have a woman director on the board. Friends, remember with me which prescribed class of companies. First, we have listed companies. Every penalty is given to listed companies. Second, unlisted public companies whose paid up share capital is 100 crore or more. Next point, or if the turnover is 300 crore or more, what do they have to do? They will also have to appoint a woman director. If you see this paid up share capital and turnover, this you will see according to the latest audited financial statements. And if your woman director's seat is, okay, one more point. Okay, listen. If there is an intermittent vacancy in the woman director's seat, meaning if there is a vacancy in between, when will you fill it? In the immediately next board meeting or within 3 months, whichever is later, within 3 months, okay? At that time, will you fill the intermittent vacancy? If it's a newly incorporated company, and if that provision for a woman director is applicable to it, then within 6 months of the incorporation, what will they have to do? Within 6 months, woman director will have to be appointed if it's newly incorporated company and the provision is applicable. Then do refer to question 53. And students, these people need to have at least one woman director. Sir, what if a woman director resigns or there is an intermittent vacancy? In the immediate next board meeting, and within 3 months, whichever is later, you have to remember that. After that, students tell me, what did I say? Sir, is it mandatory for a woman director to be independent? No, sir, in the law, in the Companies Act. The Companies Act doesn't mention anywhere about woman director being independent. We will later see if something is mentioned in SEBI Act. After that, resident director. Every company should have one resident director. Mind the word, every company. We will have at least one resident director. What does resident director mean? Who in that financial year stays 182 days or more, right? Exactly. He stays for exactly 182 days or more. And those 182 days. So if you are a newly incorporated company, then you will take 182 days proportionately. How will you take it? Proportionately. Provision about resident directors is easy. They need to be present for 182 days during financial year. Then independent directors, listen, independent directors don't apply to private companies. Divide the company into 3 parts. Listed public company, unlisted public company, private company. Private companies don't need independent directors. Registered companies need how many independent? At least 1/3 of the total directors should be independent. At least 1/3 should be independent, and in an unlisted public company. The unlisted public company we will prescribe, it requires independent directors. Which ones did we prescribe? Company whose paid up share capital is 10 crore or more, or the ones whose turnover is 100 crore or more, or the company whose outstanding loan, debentures, deposits. See, these 3 words, loan, debentures, deposits, is more than 50 crore, exactly 50 crore isn't covered. If it is more than 50 crore, then what will happen? The independent director provision will apply. These are the 3 most important limits. Paid up share capital of 10 crore or more. Turnover 100 crore or more, this loan, debentures, deposit which is more than 50 crore. So you will think the independent director provision will become applicable. But sir, when will we consider the paid up share capital and turnover? The latest audited financial statement. After that, this provision here, even if it is applicable, we will not apply on the 3 conditions. Joint venture, wholly owned subsidiary and dormant company. JBWOH wholly owned subsidiary, whether it is an unlisted public company or if its paid up share capital is 20 crore. However, that provision for independent directors will not apply to any of those 3. Did you understand? Now after that, there is a provision which you will understand better later on in section 177. But look, 149 says we need this many independent directors. If section 177 says that we need this many independent directors, then section 149 says keep mine at that. Section 149 says we need these many independent directors. Like out of 10 directors, we need 1/3 independent directors. Audit committee says we need this many independent directors. So section 149 says then keep mind this much as well. Whichever of the 2 is higher, that many independent directors we need in the company. Sir, if due to the audit committee, you need a higher number of independent directors, right? Assume that exactly that much higher number is also the requirement of section 149(4). After that, if independent director's office is vacated, then same provision for woman director applies. These months or immediate next board meeting, whichever is later after that, no need to appoint independent director. Okay, remember this. If your paid up share capital limit or turnover limit is breached once, then will an independent director stay permanently? Once applicable forever is not applicable forever. Once applicable, it will be applicable for 3 consecutive years. For 3 consecutive years, if your paid up share capital limit or turnover limit or no other limit is breached, then in that case, only then you will discontinue it, no problem there. After that, listen, the listed company definition is not very important. You just need to know that in the definition of a listed company, earlier if all securities are listed on your recognized stock exchange, then you will be considered as listed company, but now they have removed 2 types of securities. If your non-convertible debt and if your preference shares are listed, then it won't be considered as a listed company. You can read this in detail, but this is included for knowledge. Now, who can become an independent director? What are the conditions to become an independent director? I will tell you here in the notes, you can see along with me. Sir, who can become an independent director? First, remove 3 people from independent director: MD, WTD and nominee director. These 3 will never be called independent directors in life. Then I divided it into 3 categories. First of all, we talk about the individual. If we are talking about an individual, he should be a person of integrity and should have relevant experience and expertise. Then he should have experience and expertise. Okay. After that, he should not have any pecuniary relationship. He should not have any pecuniary relationship with the company, associate, subsidiary, holding or promoter or director. Pecuniary relationship means monetary relationship. With whom? With the company, associate, subsidiary, holding, or with promoter or director. In which year? In the current year and preceding 2 financial years. Now listen, this pecuniary relationship you are talking about. 3 things don't come under this. If you are doing a transaction in the ordinary course of business at arm's length price, or if there is any transaction that is less than 10% of that person's total income, if it's less than 10% of that person's total income, and third, if you are providing them with remuneration, then we will not call that a pecuniary relationship. Three things will not be considered here. First, ordinary course of business in arm's length price. Second, 10% of the total income. And third, if you are giving remuneration, then what it will not be considered? Then it will not be considered your pecuniary relationship. After that, what I said, guys, the third one, I made you remember it by IMP, P for promoter. You should not be the promoter of what? Promoter of cash. Or you should not be related to whom? The promoter or the director. Promoter or director of what? Cash. You should not be the promoter of the cash, nor should you be related to the promoter or director of the cash. If you are promoter of cash, or relative of promoter or director of the cash, so you will be disqualified. Otherwise, you will be eligible. Now let's talk about the relative. The thing about a relative is, relative should not hold securities of company associates subsidiaries holding. After that, let's read the detail a little bit. Okay, let's read. The relative should not hold any securities or interest in cash during current and preceding 2 financial years. But here is another point. Your relative, he may hold in company a face value not exceeding 50 lakh or paid up share capital up to 2% of the cash. That means you can hold face value up to 50 lakh or 2% of cash of the paid up share capital. But who can hold? Only relative can hold. Relative can hold it in the company up to a face value of 50 lakhs or 2% of the paid up share capital. So security cannot be held in cash. But it can hold security in your company up to 50 lakh face value. After that, the second point, let's read. Indebted to the cash. Friends, when you read this, I know there will be a provision about the auditor in your mind, a provision of the audit. That is section 141. So what's written in section 141? That if the holding increases, then corrective action needs to be taken within 60 days. That provision is not here. If you get it, very good. Otherwise, leave it. I was talking about the audit portion of the Companies Act. Now listen what else is there. Indebted to cash. Should not be indebted to cash or promoter or director. In excess of 50 lakh rupees, there should not be any indebtedness exceeding 50 lakh rupees in the current year and the preceding 2 financial years. Besides that, you shouldn't have given any guarantee or security in favor of any third person to cash or a promoter or a director of an amount of 50 lakh rupees. Here exactly 50 lakh is covered. Here more than 50 lakh, you have to look closely. You see, here it should be more than 50 lakh, but here the exact 50 lakh is also covered. If you have given a guarantee of exact 50 lakh, so that would also be covered, and any other pecuniary relationship with the cash of more than equal to 2% of gross turnover or total income, meaning apart from this, any other pecuniary relationship more than 2% of gross turnover or equal to total income, then what will happen to him? Yes, he will be disqualified. Who is maintaining these 4 relationships? My relative is maintaining them. If I want to become independent director, so my relative should not come in any of these 4. The definition of a relative, we will study that in detail in the next chapter anyway. But you should not fall in any of these 4. Now let's talk about neither himself nor a relative. Now we are talking about both of them. Let's talk about both. Listen to me. First, myself and relative should not be key managerial person. Neither me nor my relative should be a key managerial person in the company associate subsidiary holding in the current year and preceding 3 financial years. Neither me nor my relative should be a key managerial person or employee. Should not be key managerial person in the current year and 3 preceding financial years. But the law says that a relative can be an employee for the past 3 years. This is allowed. In the previous 3 years. That is an exception, but otherwise you cannot become a KMP. After that, you cannot be partner, proprietor, or employee. Should not be in a firm that is either an audit firm or a CS firm of company associate subsidiary holding, or that firm is a legal consulting firm that is a 10% of gross turnover is coming from our cash. 10% of gross turnover is coming from our cash. Law says if this legal consulting firm is dependent on you, then their partners, proprietors, and employees are also dependent on you. So how did you become independent? You are not independent. And after that, understand this, you with your relative should not hold 2 or more than 2% voting power of the companies. Here it is not cash. Here it only says company. You might be wondering, is it cash or company? It only says company here. The company cannot hold 2% or more voting power. And lastly, sir, you cannot be associated with any non-profit organization. You should not be associated with a non-profit organization that holds 2% or more voting power in your company, or that NPO's 25% of gross receipts is associated with a company associate subsidiary holding or promoter or director. Company associate subsidiary holding, promoter or director. These are all the conditions, friends. This is the revision. And we take a whole day, 2.5 hours to finish this whole section. Okay? But you have to do the revision in same way. What did I say? The last portion is FVNK. What is F? You are a partner, proprietor, or employee of such a firm. Please listen to me. You should remember it. What did I say? You should not be a partner, proprietor, or employee. Should not be a partner, proprietor, or employee of such as firm, PPE of any audit or consulting firm, which is of cash, or legal consulting firm, whose 10% of gross turnover comes from cash. And then after that, voting power. You shouldn't have voting power of the company more than 2%. You shouldn't have voting power more than 2%. Equal to or more than 2%, it shouldn't be. Third, now V is covered. Let's talk about N. What is N? N is non-profit organization. You shouldn't be the CEO or director. NPO's gross receipts 25% or more should not come from you. Or you should not hold 2% voting power. And the last, you shouldn't be the managerial person. Did you understand what I am saying? After that, I told you one thing. This is also an exam question. Can you appoint Mr. A as an independent director? If he is independent director in subsidiary company, can you also appoint him as an independent director in the holding company? Can you? The answer is yes. There is no such restriction. We are not prohibiting subsidiary director to appoint as a director. We are not stopping our subsidiary director from being a director in holding company. So law says it's okay. Okay, then what I said, did you remember? That from 149.6, many questions comes from 149.6, right? So many conditions, who will check them? The law states that you need to provide a declaration. What you have to provide? You will have to give a declaration. What kind of declaration will you have to give? A declaration that you meet the criteria for independence. You will have to give it 3 times. First, while attending the board meeting for the first time. Second, in the first board meeting of every financial year. And third, whenever there is a change in circumstance that could affect your independent status, at that time you should give a declaration. Whenever there is a change in circumstances that could affect your independent status. After that, subsection 8, which is schedule 4, compliance is to be done. 4 is half of 8, 4 compliance is to be done. Number 9 states independent directors shall never be entitled to stock options. Remember this line. Never be able to receive stock options. So you can receive 3 things. What can be given to you? You can get fees under 197.5, meaning sitting fees can be given to you. Second, you can get reimbursement of expenses. You can get reimbursement of expenses and participation in the meeting. And third, you can receive profit related commission. Profit related commission as may be entered by member. Okay. Profit related commission as may be approved by members. Profit related commission as may be approved by the members, okay. After that, in case of no profit or inadequate profit, independent directors can receive remuneration, excluding fees under section 197 subsection 5 as per schedule 5. If independent director, if a company gets inadequate profit, previously there was no provision for it. Now you will get paid according to schedule 5. Then what all can you receive? Fees, reimbursement of expenses, and profit related commission. What's third? Profit related commission, profit related. If you talk about other things in chat which is not relevant to the topic, I will block you. Please guys, I get distracted. Please don't distract me. My flow breaks. Please guys, for the students who are reading, you guys please just reply in the chat so that I won't see the other messages while I'm reading, so that I understand someone is listening. Please guys, stop doing it. Dristi, thank you. Let's go. And what will be term for independent director? Most important. You know very well that an independent director can be appointed for up to 5 years. They can be appointed for up to 5 years. Then after that, you will pass OR to appoint. Next, can they be reappointed? Yes, they can be reappointed for period of 5 years. But remember, to be reappointed, have to pass SR. But the maximum you can have is 2 terms. After 2 terms are over, what will you do? Go to cooling period. Have to go to cooling period. How many years of cooling period? There will be 3-year cooling period in which he shall not be associated with the company in any capacity, directly or indirectly. And in this way, you will not be associated. After that, what I said is a very important provision. When you reappoint independent director, then you will have to pass SR. You will also have to disclose it in board report that we have passed the SR. After that, what did I say? Independent director and non-executive director. Listen carefully. What did I say about independent director, non-executive director? Independent directors and non-executive directors are not always liable. They are only liable in 3 cases. The first one, with their knowledge. Something happened because of their knowledge. What is the second point? The fault was attributable to the board process. And third, something which has occurred with their consent or conviction and for which they failed to act diligently. Either they gave their consent or they did not do work properly. So whatever happened because of that, they will be liable for that. Liable for 3 things: KBC, K knowledge, B board process, and C content. They will be liable for this. They will not be liable for anything else. What is an independent director? They do not retire by rotation. Independent directors do not retire by rotation at all. After that, come to section 150. Listen carefully to what I am telling you on the screen. See here, it will be finished. And what is 150? Listen to me, guys. Law says that we will create data bank. We will create data bank that includes every director eligible for independent director and willing to become independent director. We will create data bank here. In the data bank, what should we maintain? We told ICM NSR, we told Indian Institute of Market Affairs. Manage it from data bank. Now listen to me. Every person eligible and willing, he will include his name here. From here, who will take the name? The company will take it. But is the person independent to the company or not? Tell me. Who is responsible for conducting due diligence? That due diligence is the responsibility of the company. Is DIN required to include name here? No, DIN is not required. Your name can be included without DIN. Listen carefully to me now. When you enter your name, there is an option given. Should we do it for 1 year or 5? You can take it for lifetime. If you get it done for lifetime, then no problem. And if you get it for 1 or for 5 years, you will have to renew your name before the expiry of the period, before expiry. Moreover, if you really wish to renew it, you will have to renew it. Someone was saying we will try on 1.5x, let's do it. Try it. If anyone is watching this video, please comment that you are watching at 1.5x. I would like that. Then listen to me. What am I saying? You can adjust speed as you like. I will read in my own flow. My flow is good. You make flow as per your liking. Slow down the speed of my video, but listen to what I'm saying. Will you adjust it for 1 year or 5 years or infinite period and have to renew it before expiry? After that, what did I tell you? Once your name is uploaded to the data bank, what do you have to do within 2 years? You have to give exam called OPSAT, Online Proficiency Self-Assessment Test. Now see, you will take online proficiency self-assessment test within 2 years. What percentage is required to pass? You need 50% to pass. And we need 50%. Can you tell CA students how many attempts? There is no limit on the number of attempts. Here too, they keep giving it, okay. OPSAT Online Proficiency Self-Assessment Test. Will Mukesh Ambani also go and give exam? No, they have exempted 2 types of people from giving OPSAT. One having 3 years of experience. Others having 10 years. Who all are with 3 years experience? First, if you are director, key managerial person in big firms. Large companies in India means the companies that are listed, or those unlisted public companies whose paid up share capital is 10 crores or more than that. After that, in India, the body corporate that are listed abroad. Besides body corporate listed outside whose paid up share capital is over $2 million. Or in addition to that, any statutory corporation, right? If there is any statutory corporation. Therefore, what needs to be done with that statutory corporation? If you are director or key managerial person, you are there for 3 years, then you don't have to give this provision, this OPSIT exam. Now we will see that who all will be saved if you are from a listed public company or unlisted public company with share capital 10 crore or more. The body corporate listed or unlisted. If paid up share capital is $2 million or more, if it's statutory corporation, 5 people will do something. If any of these 5 people are director or key managerial for 3 years or more, then you will be exempted. Okay? I have 1 year of experience in Tata Motors. I have 2 years of experience. But when I had 2 years of experience in Tata Motors, as a director, at the same time, during the same time, I was also working in Adani Enterprises. Will these 2 and these 2 years be counted as 4 years? No, if you are a director or a key managerial person in more than one company at the same time, that will be counted as 1, and I have written it here. What have I written? I have written that if more than one company, count once. If more than one company, count it once. Okay, let's remember it like that. Clear? Very good. What is point B? First point is who is a director or key managerial person in these companies. Second, if you are a director or in ministry or department of CG having experience and following, what is your experience in this field? If experience in commerce, corporate affairs, finance industry, public sector, or if you have experience in any other affair related to a government company, then you will be exempted. I hope this point is clear. Furthermore, remember this. If you are a director or someone at that level in a ministry or a central government department, in ministry or in central or state government department, you are director or at similar level and have experience over 3 years, you will be exempted. And last, if you are with SEBI, RBI, IRDA, PFRDA, what are in these places? Or at chief general manager or above that pay scale? Pay scale means salary. Law said you will get exempted, but condition is that you should have 3 years or more experience. While those who have 10 years, those with 10 years of experience, we still don't fall under that category. But like advocate, CA in practice, also the CS in practice, or cost accountants practice. All these people have 10 years or more experience, then they don't have to give OPSAT. don't have to give it. In rest of the world, everyone will have to give OPSAT exam. Clear? After this, an amendment came. What is it? Tell me. An amendment has come. Listen carefully. I have uploaded separate video about amendment in detail. If you give OPSAT within 2 years. If you don't give OPSAT in 2 years, what will happen? It will be removed. After the name is removed, you can apply to ICA and request to restore your name. To restore it, you have to pay 1000. When your name is restored, it won't be visible. You will see your name in separate restored category, and you will have to keep your name there for 1 year. Furthermore, within 1 year, you will have to clear OPSAT exam. Okay? And if you pass the exam, then you have the period for which the fees was paid initially, and you can enjoy your name there till then. But if you fail the exam, your name will be permanently removed, and now you will have to fill out a fresh application. You won't get another chance to give OPSAT exam. You have to fill out fresh application. That means you have to pay full fee that you paid initially, right? This amendment is in your notes. If it's not, I have included these notes in other amendment video. And those who are ordering today, they will all get these notes. What is section 151? It talks about the appointment of directors elected by small shareholders. Appointment of directors elected by small shareholders. Listen carefully to what I'm saying. To whom is this provision applicable? It's applicable to listed companies. In listed companies, appoint small shareholder director. How to appoint small shareholder director? Either suo motu or someone has given you an application. Small shareholder will give the application. What is small shareholder? Those people who hold nominal value of 20,000 or equivalent, less than or equal to 20,000. Pay attention. You won't remember this in exam. Even if it's 20,000, you will be called small shareholder. Small shareholders give application to company. How many people will give application? Either 1,000 small shareholders or 1/10 of total shareholders. So whichever is lower, whenever flat number comes, lower it. 1,000 small shareholders or 1/10 of total small shareholders will give application. When application comes, it will come at least 14 days before meeting. In this application, names, addresses, folio number and shareholdings of people who are submitting. Name, address, shareholding and folio number. These 4 things are written, and along with it, name and address of the person you want to appoint should also be given. And you should also give their name and address. And if there is folio number and shareholding, if there is folio number shareholding, give it. This shows that even if you aren't shareholder, you can become small shareholder. If you don't even hold 1 rupee share, then you can become a small shareholder. After that, you will be given. You need to provide 3 things if you want to become small shareholder director. You need to give DIN. Give declaration of your disqualification under section 164. You have to give consent. These 3 things, you should remember these things. And this has to be given by every director. DIN. Declaration you are not disqualified under section 164 consent. Okay? Is small shareholder director an independent director? Tell me. I don't know. According to you guys, you come in class and you say the answer is yes, but I have already proved it to you in class that it's no. But I can't prove it to those who haven't taken the class. So you understand, are small shareholder directors independent directors? In exam, when such question comes, you write small shareholder directors shall be considered as independent directors subject to section 196 and 149.6 and 149.7. Subject to 149.6, 149.7. It's up to you. Read word shall and be happy. But write shall be considered as independent director if eligible under section 149.6, 149.7. Will they be rotational? No, these directors will not be required to retire by rotation. These people won't retire by rotation. What's tenure and what happens then? You have 3 years. Can they be reappointed? No. What happens after that? After 3 years, cooling off period will come. 3 years of appointment, 3 years of cooling period. So first hot, then cold, then hot, then hot, cold. What happens to independent directors? Hot. Then after that, if you are reappointed, it will be hot again, cooling period, and then it will be cold. Hot and cold, going through hot, cold, hot, cold. What is going on here? What is going on with this hot and cold? Let it go. I told you. You are appointed for 3 years, then 3-year cooling period. Reappointment cannot happen during that time. Then reappointment happen. When do you have to end your office week? If you are disqualified 164, your office becomes vacant in 167. Or if you stop complying with condition of 149.6 or terminate, your office will become vacant. Okay? And what is the restriction? You are at given point of time. Listen to me. You can be maximum of 2 companies SSDs at a given point in time. And those 2 companies, competing or conflicting businesses should not exist. Those 2 companies should not have competing or conflicting businesses. Did you understand what I said? Okay. And what is this? Entire SSD provision is done. Small shareholder means whose nominal value of share is 20,000 or less. How many people will apply? 1,000 small shareholders. 1/10 of total small shareholders, whichever is lower. How many people will apply? And you will have to give your DIN to be appointed. They can't be disqualified under 164. You have to give your consent. After that, section 152 starts. 152 starts. Listen to what I'm saying here. What 152 is saying? First thing it says, how will first director be appointed? How is first director appointed in company? That is written in your article association. In articles, you either directly write name of first director, and if you aren't writing name, tell me about manner of appointment, how they will be appointed, but this is about AOA. If the name of the first director is not mentioned in EOA, your subscribers to the memorandum, and they will be considered the first director. And listen, in the case of a one-person company, the sole member, same person is considered first director. This is provision for first director. What did I say? If you want to become a director, how will you be appointed? Unless otherwise specified? Unless otherwise specified, meaning if we haven't stated it. Then how were you appointed? Tell me. Unless otherwise specified, you are appointed in general meeting by ordinary resolution. They were appointed in general meeting by resolution. Furthermore, third, if you want to become director, you should have the big DIN. What should be big? DIN should be there. DIN is very necessary. Without it, you cannot become a director. If you want to become director, you need DIN. You will have to submit your DIN and you will have to give declaration that I am not disqualified in 164. Then you can become director. What does section 5 say? Listen to me carefully. Come along with me, please. This is related to party under section 188. We will read about it in later section. This is not rocket science. It's from simple section. What did I say? Tell me. And after that, I said if someone wants to become director, they need company's consent. As soon as consent is received, company will send it to ROC within 30 days. In which form will you give consent to company? You will give in DIR2 form. In which form company will send? They will send in DIR12 form, but wait a second, there is amendment now. You will have to give one more thing along with this consent. Furthermore, let's say that if you are an individual, you are not an Indian, you are a national of some other country. Okay, is that clear? Countries that share land border with India, what do they share? Land border. Land border means Pakistan, Afghanistan, all of that. If they share land border, if you are national of that country, have to get security clearance in India. National security clearance. Who will give national security clearance? Mr. Amit Shah, the Ministry of Home Affairs will give, Government of India will give. National security clearance needs to be attached with consent, then will it be considered a valid consent. Moreover, what needs to be attached? The Ministry of Home Affairs national security clearance needs to be attached. After that, see subsection 6. Subsection 6, listen carefully to what I'm saying. Your total number of directors. Next, subsection 6, what does it say? Forget about first AGM. Except for the first AGM, forget the first AGM. What will subsequent AGM do? Unless article provides for retirement of all directors, the directors, what will be in subsequent EGMs? From total number of directors, 2/3 of directors shall be rotational director, and maximum of 1/3 will be non-rotational directors, and of those 2/3, 1/3 of directors shall retire by rotation, and remaining 2/3 will be safe. Here, 2/3 is at least, meaning you have to take minimum here. If total number of directors are 10, 7 will come here. Because your 6.67, you will round up to 7. Moreover, we always round up. But when you take 1/3 of 2/3, then we always round off in math. Math round off, what does it mean? 2 for 2.3 and 3 for 2.67. This is how it works. But here you would say 3 for 2.3, okay? Because here the word used is at least. So what did I say? Total number of directors, 2/3 of them will be rotational directors. Maximum of 1/3 will be non-rotational directors. Now, who will retire? Director who is appointed in general meeting can retire in general meeting. Moreover, if the director is not appointed in general meeting, he will not retire in general meeting. Will you do the calculation in this way? The question is, who will retire? The one who has been in the office the longest will retire. The one who is the oldest in the office. But suppose 2 directors are appointed on same day. How to decide? Law says first you should decide by mutual agreement. If you decide by mutual agreement, then very good. But if you can't make decision by mutual agreement, so we will draw a lottery. And determined by lot, that means we will draw a lottery to decide who will retire and who won't. We will decide by mutual agreement and sends it. What happened here? Your total is 152, subsection 6. But there are variations. I won't explain, just inform. Total number of directors includes 2 or 3 people. Total number of directors does not include 3 people. Independent director never comes. Why? Because it is written in your 1 for 913. Independent director is not included in total directors. Who else? Second nominated director does not come. Appointed by public financial institution. Third nominee director does not come, appointed by LIC. Why? Because it's written in LIC Act. Our directors don't retire. Body that governs public financial institution. It says that our directors don't retire. Don't include it in total number of directors. If there is a nominee director, It came from the agreement. Law says you have to take them in total number of directors. Don't take these two. What did I say then? Who comes under the non-rotational director? Non-rotational directors are those appointed by the board. You have an alternate director, such as the casual vacancy director, or your nominee director, and all these come where? They come under non-rotation directors. Directors who are board appointed it. The MD and WTD. Are these rotational or non-rotational? It can be anything. It depends on their terms of appointment. Whatever you wrote in agreement, if it's rotational, then rotational. For non-rotational, it's non-rotational. So this is your retirement provision. This time I added special notes. Total number of directors, rotational 1/3. Which 1/3 will retire? How will they retire? On FIFO basis, longest in the office. If appointment is on same day, you will determine it by mutual agreement or by lottery. Total number of directors, meaning the limit of 10. In that you will not include 4 people. Okay. Independent director. Nominee director appointed by financial institution which is set up under Act of Parliament. Nominee director who is being appointed under the LIC Act. But one more person is still not here. Alternate director. Mistake. Alternate director won't come in non-rotational. Because it's non-rotational, don't include it in number of directors. The alternate director will not be included in the total number of directors. And it's questioned like this in your question bank. Who will be included in total number of directors? Nominee director not sent by financial institution. Furthermore, if director is appointed in 161, include him but do not include the alternate director. And after that, director appointed in general meeting can retire and the directors appointed in 161 for a casual vacancy. That will be non-rotational and the MD and KMP will be rotational or non-rotational will depend on their terms. After that, listen carefully to me. What did I say after that? In 152.6, retire, but after retirement, you have to do one of 3 things. Okay. Or you can reappoint the retiring director or appoint a new director. You can expressly resolve that we will not fill this vacancy. We don't need, we won't fill it. Have to do something from all 3. If it is not done, your meeting will be adjourned. When will it be adjourned? Same day, same place. Next week. Same time, same place, same day. Next week meeting will be adjourned. If that day is a national holiday, then the next day which is not a national holiday, you will have to adjourn meeting. In adjourned meeting, you will have to do one of these 3 things. If none of these 3 things are done, meeting will not be adjourned again. Now what will happen to the meeting? Directors who were retiring, you will automatically reappoint them. And you will automatically reappoint those who were retiring. But there are 5 cases where automatic reappointment does not happen. I had told you the shortcut LWR 164 162. Now what is L? Lost. If we had tried to appoint them earlier, that resolution failed. Therefore, in that case, we won't automatically reappoint them. W is willingness. If they had given their willingness or unwillingness in writing that they don't want to be director in your company, clear, you won't automatically reappoint them. Third, if resolution is required, it is written in law that OR or SR will be required for their appointment. OR or SR will be required. If it's disqualified in 164, how will you automatically reappoint? If 162 means separate votes for each director, if this provision is applicable, you won't automatically reappoint them. In 5 cases, automatic reappointment won't happen. LWR 16462. Lost. Willingness. Resolution. 16462, 5 provisions are done. Understood, guys? Tell me, did you understand? Let's move on to next provision. What is the next provision? This completes your entire section 152. 153, this is where DIN provision starts. I will tell you it will be over. Listen to me. Hence this time, I am revising it for you in this way as I find it more effective. Okay? You can read it from book but read this once. What does 152 and 153 says? You will give the application for DIN. What will this person do? He will give application to central government for DIN in the form DIR3. In DIR3, please give your name, address, many ID proofs. Give address proof, all the attachments have to be given and along with that. Moreover, it also needs to be verified, and who verifies it? The company CS, CSEO, CFO. Okay? These people verify. When this DIN goes to the central government, if you take DIR3, then section 154 becomes applicable. Now it says that application number will be generated. This will be decided based on application number. Whether you will get the DIN number or not. If this application number, after it's generated, central government will check. Within 1 month, it will either give DN or not. If DIN is done, it will allocate DIN number and will send it to you by post informing you that DIN has been allocated. Okay? If after giving application number, any defect is found or incompleteness, then it will give you 15 days time. You will rectify it within 15 days. What can happen? Either you rectified it completely. If you have completely rectified it, then he will allocate DN, but it's possible that you completely ignored it. You didn't take any action. If no action is taken, then your DIN will be declared invalid. However, if you have partially rectified it, then it will say you are crazy. Now, did your mind go crazy? If you have partially rectified it, then it will say that your application is rejected and now go and file a fresh application. Okay? But amendment has come. Application number that is generated, Furthermore, this application number will not be generated if you are a national of a foreign or from any of those countries who shares the land border with India, and in order to generate that application number, you will have to get a national security clearance. What will you do? You need to obtain national security clearance. Only after that you get application number generated. Okay? Understood. Is it clear? I do that intentionally. These things remain under my control. Is it clear? Therefore, this is all of your entire provision. Now pay attention. What does put under resubmission mean? This means that you need to submit the documents again and need not to file anything fresh or new. You have to submit documents. What does 150 say? It's prohibited to have more than one DIN. You can get just one DIN. 152, 156 and 157 are transition provisions. If you have been a director before and you got DIN later, if you became a director and you received the DIN number later, so give the intimation in DIR 3B to company within 1 month as you file DIR 3B. Then the company will intimate the ROC in DIR 3C within 15 days. If you have contravened, then a penalty will be imposed. But you can mark this as not important, but might be asked in the exam. I just can't say it won't be asked in the exam, because I think the ICI also watches my video. What is section 158? Obligation to indicate. I will mention this DIN number in every RIP return information particular. You will have to intimate this DIN. You will mention your DIN in every return information particular. If contravention of section 152, 155, 156 happens, you'll have to pay a penalty, 50,000 rupees and 500 for per day. 50,000 rupees, 500 per day. Now this is an important provision. Can your DIN be cancelled? This is an important provision. The question is, can DIN be cancelled or deactivated? Yes, it can be. If the central government or the regional director finds out later on that DIN has been duplicated, or if in case you obtain DIN fraudulently or due to death, unsound mind or insolvency, the way to remember this is FUDIS. FUDDIS. F stands for fraudulent and U is unsound mind. What is DD? Death. And other D is duplicate DIN. I is insolvency, and what is S? If the other party has surrendered DIN by submitting form DIR 5, if the DIN has been surrendered by submitting DIR 5. So whenever you will surrender, you'll need to give a declaration. That DIN wasn't used for filing any documents. Then you can surrender. What will happen? In that case, if you surrender your DIN, so your DIN will be either cancelled or deactivated. Suppose you have filed DIR 3. Let's say you gave some information in DIR 3 that is now irrelevant or changed. Let's say that you put male gender, but you have got your gender changed to female. So you will have to intimate the CG. The gender's been changed. So you have to intimate within 30 days by filing a DIR 6. The CG will verify by its own methods. Once it is verified, the CG will inform applicants and ROC that changes are done. And after that, directors also have to inform the above changes in DIN to the company within 15 days of such change. Within 15 days, you have to intimate these changes are done. Now section 160 is about right of a director other than retiring director to stand for directorship. Yes, Rahul. Don't force me to block you because of spamming. Now listen. Pay attention. What I said. That section 160 is very important. So section 160 is about right of a director other than retiring director to stand for directorship. If this person wants to be a director at Reliance Industries, so then he will have to apply, or on his behalf. A member will apply, either he himself will give it or a member of Reliance Industries will apply on his behalf. He will give application along with the deposit. He wants to be company's director, and you will submit this application at least 14 days before the general meeting. And you will give a deposit of 1 lakh rupees along as well. As soon as Reliance receives this application, they will send it to the members. But how? You may send individual notices and upload on the company's website. But if you are unable to send individual notice, so notify in newspaper. We need to notify on the website. If you can't send individual notices, notify in newspaper. After informing in newspaper, you need to put it on website. This way you will intimate the members at least 7 days before the meeting. Now listen, this deposit of 1 lakh rupees, will this be refunded? Yes, this will be refunded. If this person whom we have nominated, either he is elected, or if he gets more than 25% of votes, if he gets more than 25% of total valid votes, even then his money will be refunded. But now law comes and the exception comes in. About the deposit. The deposit generally is 1 lakh rupees. But in some cases there is zero deposit, no deposit is required. First, about appointing an independent director. Second, if the nomination remuneration committee is recommending. Third, the company to which the NRC is not applicable. And if the board of that company is giving the recommendation, in that case, in all 3 cases, deposit will become zero. In some cases, the deposit even becomes 10,000. Deposit of 10,000 rupees is in the case of Nidhi company. The deposit can't be taken more from Nidhi. How will you take more? We'll take 10,000 rupees. And that too if he gets elected again. Or over 25% votes. Then money will be refunded. Now the matter of refund. You will refund if you are elected or if got more than 25% votes. Is there any exception? Law is incomplete without exceptions. Section 8 company. If your refund in Section 8 company, the board of directors has been given the power. They can refund as per their discretion if even 25% or less votes get. So refund can be done easily without any problem. Is this clear? Have you understood? I hope this is clear to you till now. Did you understand or did you not understand? The whole provision is covered, and let me tell you, this provision will not apply to 3 types of companies. Private company, 100% government company and their subsidiaries, and Section 8 companies, which are written in the UA with elections by ballot. It won't apply to private. Government. And those Section 8 companies that are conducting elections through the ballot will also not be applicable. After that, we read Section 161. Now Section 161, pay attention here. The Section 161 talks about 4 types of directors. First one is additional director. Focus on each concept, you won't realize when it's done. What does Section 161 says? I don't need the book, I have already memorized everything, focus here. They ask, where is your book? I don't need it. Pay attention here, what does Section 161, subsection 1 say? Who is an additional director? The law states that if a power is given in the article of association, so a company's board of directors can appoint an additional director. This additional director can be anyone. But keep this one thing in mind, that if he fails to get appointed means you tried to appoint him at general meeting. But if he doesn't get appointed, then you can't appoint him as an additional director, appoint someone else. What is tenure of additional director? The tenure of additional director will be until next AGM, or the last due date for holding the AGM, whatever is the last due date. And now listen carefully what I am saying. This appointment you have done. You can do the appointment from the board meeting. You can do this through resolution by circulation. You can do it from the board meeting or through resolution by circulation. This is additional director. This is the provision for additional director. After that, come to alternate director. What are alternate directors? If a company's original director go outside India for 3 months or more, so the company can appoint an alternate director in place of the original director. Remember, this alternate director is not the proxy of the original director, understood? After that, what did I say? What is the tenure of an alternate director? It remains until the original director returns. Or this continues until the original director's tenure ends. Its tenure remains till that point. Now the question is that who cannot be an alternate director? If a director is already in the company, if you're alternate director for someone in company, so you can't be an alternate director again. I explained to you that if Tiger is going out, original director, so Andrew Tate, the new partner of Disha Patni, you can also make him an alternate director. But he's not a proxy of Tiger, he is the director on his own will. Right? Directorship. After that, now if one original director is independent director, so the alternate director in place of him, he will also have to comply with 149(6). This is the provision for alternate director. And that is all about it. Who gives the power to appoint an alternate director? Either articles of association, or if not there, you can also get the power by passing OR. If shareholder informed by passing OR, then you can become an alternate director. Now, after that, nominated director. Who is a nominated director? It means if because of law, or due to agreement, or because of the central government or state governments being a shareholder, because the central government or the state government are shareholders. If you are appointing a director in the company, so it's a nominated director. If the board of directors in their board, due to the law or due to agreement or due to central government or state government, if a director is appointed, it is a nominated director. And most important, casual vacancy. Pay attention here. If a director was appointed in general meeting, if in any case his office is vacated before completion of the tenure, it's a casual vacancy. Board of directors will fill the casual vacancy within how many days? Not given in law. This means if you want to fill it, you can. If it is not necessary, then don't. But the board of directors will fill it, and after filling this, what will you have to do in next general meeting? it will have to be ratified by the shareholders, approved by them. This is the provision for casual vacancy, if the office is vacated before the tenure. So, it's okay, Ravi, you can just get it printed if you don't want to write this all. It's not a big deal. Is it clear? Now suppose ICAI brings out an amendment. I can't just magically do it for you. You need to put in some efforts, right? Clear? Did you understand? You should also put in some efforts. It's for your benefit. It is my responsibility, I admit, but yours is even more, right? Nominated directors done, casual vacancy points done. One thing important is about casual vacancy. The director who was appointed, till when he will hold it? He will hold it for remaining time for what? He will hold it for the remaining period. If original director is still there, he will be in the office till director is there. Students, did you understand? But remember one thing here in section 4, who is giving the power to fill the casual vacancy? Not the AOA or ordinary resolution. So who gives the power? It's given by the law. It is coming from the law. And remember one thing, if I talk about resolution by circulation, so then you appoint in the board meeting. When you appoint there, so the resolution can be passed by the RBC. When it is about filling casual vacancy, you'll have to meet in board meeting. You can't appoint him by a resolution through circulation. Note these 2 points because it can be asked in MCQs. Now, after that, section 162. This is very easy. This is very easy and I will tell you very simply. The law says, if you are appointing different directors, for every director, you will pass separate resolutions for each director. Separate resolutions for each director. If you want to appoint all the directors by a single resolution, so before passing this resolution, you will have to pass another resolution in which you will have to get consent from the shareholders. We are going to pass a resolution to appoint all the directors together. And this resolution that you are passing, it should be unanimously approved without any votes cast against it. Only in that case you can pass this motion. What is in the law, what is given in legal terms? At a general meeting, this provision applies in a general meeting. A motion for appointment of 2 or more persons as director by single resolution shall not be moved. It can't be done in one resolution unless proposal to move such a motion has first been agreed to at the meeting without any vote cast against it. Meaning you have first moved a resolution and you asked, should I appoint everyone together? If the first resolution was unanimously voted, so you can move the next resolution. But if you move it without asking, then what will happen? It will become void, right? Remember, this provision only applies in a general meeting. That provision is not applicable for board meetings. I hope you understand this. I'll just tell you section 163 once. It is not important. Just listen about section 163. What is section 163? But I won't be able to explain to you in this revision. And you know, the state assembly's voting system is completely discussed here. What I am saying, section 163 says option 2. Adopt proportional representation is a method. This is one method through which minority shareholders are protected. So this provision, it overrides the entire act and it states that in AOA you can write that the appointment of not less than 2/3 of total directors, at least 2/3 of the directors, they will be appointed by proportional representation. They have mentioned 2 methods in proportional representation. First is single transferable vote and second is cumulative voting system. And this director will be appointed for 3 years. And if the director's tenure is vacated, so it will be casual vacancy and filled as per section 161(4). So the company can opt for the proportional representation. If it opts, it will be filled by either single transferable vote or cumulative voting system. After that, section 164, it is very important. It is in 3 parts. Pay attention here. And please like the video. If you enjoyed this video, do like the video. Okay. I don't want to say it. You guys should like the video. You'll do it, right? I hope that every person who likes this video gets full marks in the exam. Make sure to like it. Now let's get back to the topic. So, what is section 164? It is disqualification of a director. What comes under disqualification? First is individual's point. Which individuals are disqualified? Focus here. If someone becomes of unsound mind, they are disqualified in case they become unsound mind. If someone called me crazy outside, will I be disqualified? No. Only if I am declared unsound mind by a competent court. And then what is the next condition? If you are undischarged insolvent. It means proceedings against you are still ongoing and not yet concluded. What is third? It is, if your application for insolvency is still pending, it has not been accepted yet, it is pending. If the admission is pending, then the law will say to disqualify. After that, next is, if you have been convicted for a criminal offense and if that offense is involving the moral turpitude or otherwise, be it there or not. If you have been convicted and if you have been in jail for more than 6 months, so until you are released from jail and 5 years from your release, you will be disqualified. If you have been in jail for 7 years or more, so you will be disqualified forever if you have been convicted for any offense. And whether or not moral turpitude is involved, and if you have been in jail for 6 months or more, you'll be disqualified for 5 years after being released. But if you have been in jail for 7 years or more, you'll be disqualified forever. And if any court or tribunal passed any order, if that order is still in force, you'll be disqualified. After that, calls. If you hold shares of a company and you did not make payment for the call, since the last due date for the call, a period of 6 months has elapsed, so you are disqualified. One common question is always asked here. Are these shares of the company or are these of other than the companies? Question isn't asked on this, it's your interpretation. My interpretation may differ with yours. There is no strong answer for this neither case law. As per law, if you make any delays in calls of any shares held by such person in the company, or if you delay the calls in any shares, if 6 months have elapsed since the last due date, law states you'll be disqualified. Will you be disqualified forever or for some period? There's no period, so you're disqualified forever. And then what is next? If you are in contravention of 188 in the last 5 years ever, so you're disqualified. You'll be disqualified if you lack a DIN under 152(3). If you exceed the maximum number of directors under 165, then you'll be disqualified. This is the disqualification for individual. What was the method to memorize it? Call from IIM. They will offer you a big package of 188, 152 and 165. Then someone will pour water on you to wake you. For the exam, firstly, what is IIM? If you are an undischarged insolvent and then your insolvency application is pending, what is M? It is unsound mind. What is CALL? What is this call? You have an arrear in your calls. Off is if you have convicted offense or there is order of tribunal. Contravention of 188 in last 5 years. No DIN obtained under 152 or if breached the limits under section 165. If you have breached the limits, then law states you will be disqualified. After that, subsection 2 is extremely important one. You all know this because you are revising. Pay attention. What does this say? If a company does not file their financial statements or the annual returns for 3 consecutive years, or if a company who has defaulted in deposit, debenture or in dividend. In the deposit or debenture or dividend, if 1 year has passed since they have defaulted, the default has been continuing for 1 year. So all the directors of the company cannot be reappointed in that company and cannot be appointed in any new company. For a period of 5 years, you cannot be appointed for 5 years in any company. Can't be reappointed in same company or appointed in a new company. Now this has become a defaulting company. Okay, so if you bring in a new director to a defaulting company, the law states that for next 6 months, nothing can be done and he can't be disqualified for 6 months. After 6 months, if this default still continues for 6 months while he is in the company, then he will also disqualify. And then next, if you are disqualified once, you're disqualified for 5 years on the day of default. The very next day, if default is good, it doesn't matter. For 5 years, you will be disqualified. Do you understand? Students, did you understand or not? Yes. Therefore, this is the whole provision, okay? This is your entire provision. And now listen to me. If you are being disqualified, so whenever the new director is appointed in the company, a DIR 8 needs to be filed and informed under 164 in subsection 2. And if in case any company is defaulting, then who has defaulted these two? So what he will do? He will have to file a DIR 9. A DIR 9 must be filed within 30 days to ROC and must inform that these are the directors who have been disqualified. 2 forms are discussed, a DIR 8 and a DIR 9. Are you understanding what I am saying? Because I'm having a lot of fun in teaching this concept, but I am not sure if you are understanding. But I am explaining so many provisions in detail. I have no words. Okay. Let me tell you that I didn't leave out a single point in the revision. I think I need to get this all revised at 10:30. Next comes the third point. What is given in the third point if it's a private company? You might be thinking I am praising myself, but no, I'm not. Have I done it before? No, I'm just saying it. I'll tell everything. If the private company wants, So it can tell the additional grounds, it can give the additional grounds in the AOA because of which you will be disqualified. Who will tell about the disqualification? The private company is the only one who can explain the disqualification. So this section 164 is all complete. So is there a penalty on contravention of 164? No, there's no penalty. 164 is completed. Now let's move to 165. 165 is very simple. Your maximum number of. Don't like it twice, do it thrice. Listen.
Sir, मेरी बात सुनो.
165 states maximum number of directorships. What's the maximum number of directorships one can be appointed to? The law states at any given point of time, a person can be a director in 20 companies. In public companies, directorships are limited to 10. When you count private companies, when you count the limit of 20 companies, right? You should exclude dormant companies. When you count the limit of 10, right? The private company should also be included, which is either a subsidiary or holding for any public company, either holding or it's a subsidiary. You count both private companies. If its public company is holding or subsidiary. So if there's a private company whose subsidiary is a public company, right? So would you also count that private company? You'll count them both in limit of public companies and in 10. Then calculate maximum number of directorships. If a shareholder of a company wishes, if a Reliance shareholder wants, then he can pass SR and can tell his directors that you won't work for maximum of 10-20 companies. You'll work in a lower number of maximum companies. So he can say to his director, he'll work in 2 other companies besides here. You can impose such a restriction by passing SR. It's your full right. Now, if you go beyond your limit and work, in that case, you have contravened. What will be the penalty? 2,000 rupees per day penalty will be imposed to a maximum of 2 lakhs. Penalty will be to a maximum of 2 lakhs. After this, we'll move to the next section. Next section is 166, duties of director. This is your duty. That working in AOA, working in good faith, apart from that, don't let conflict arise, work in good faith and do due diligence. What did we read at the end? Don't assign to our office. If it's assigned, then what will happen? It will become void. If assigned, it will become void. Why can't we assign? If you die or in unfortunate events, then your office becomes vacant. So you can't even assign. If done, it becomes void. Now, if you contravene this, you'll be liable to a penalty of 1 lakh to 5 lakh rupees. It's done. There's nothing much. 166 is done. Just leave it. Don't leave it. It's important. Read it. If there's any important section in the world, it's section 167. This is it. It's 149.6. But this 167 is also equally important. Okay? Let's talk about vacation, guys. When will your office be vacated? 8 grounds for vacation. Listen carefully. The first ground is vacation. Your office will be vacated if you're disqualified under section 164. But if you are disqualified under section 164 too, right? The company that is defaulting, you won't vacate in that, you'll vacate it everywhere else. You won't vacate in a defaulting company, you'll vacate everywhere else. You know, there's a tube light question in your book bank. So 164 is done. Later, what did I say? If you don't attend board meetings for 12 months, whether you have taken leave of absence or not, it does not matter at all. If you continuously didn't attend any board meeting for 12 months, so you will be disqualified, you will have to vacate your office. If under 184, you did any contravention, or if in 184 you entered into any contract or arrangement and you did not disclose your interest, in both cases you will vacate your office. Then I said, if you've been convicted for any offense, or you've been in jail for 6 months or more, or there's a court order that's in force, so in both cases what will happen? Your office will be vacated. If you have been removed under the section 169, if you have been removed. Lastly, you became a director for this reason, as you were employee of associate subsidiary holding company. Now you've completely ceased being employee here. So nothing to be a director here. I had given you the example of Reliance Industries and Reliance Jio. If you're a director of our company as you're an employee elsewhere, you were an employee somewhere but you're not working there anymore. What will you do becoming our director? In these 8 cases, your office becomes vacant. But these 2 are special cases. Listen here. If jailed for more than 6 months for an offense, or if an order is passed against that, you're disqualified. So you won't immediately vacate. You'll get 30 days time. In those 30 days time, you can appeal and you'll receive appeal order. Despite the appeal order, you will get another 7 days time, which means you can file a second appeal. When second appeal order comes, right? This order will be final and binding. Based on this, you will have to vacate the office. This provision of appeal, right? 30 days and 7 days, these 2 appeals, it's only in 167. This provision is not in 164. This provision is not in 164. You get it? This was 167. See here. Will you get an opportunity of being heard to vacate your office? No, as soon as appointment's made. As you make a mistake, you have to vacate. Tell me, can the board waive any of these grounds? Waive means, can we say like no issues, you didn't attend for 12 months, will forgive? No, the board cannot waive these grounds. Now tell me one thing. If all the directors vacate together, so what will happen? Either the promoters will take over or the central government will appoint the minimum number of directors, okay? Promoters will take over or central government will appoint. It will continue in this way. But even after your office is vacated, despite vacating, if you are continuing, you'll be penalized from 1 lakh to 5 lakh rupees. Understood? 1 lakh rupees to 5 lakh rupees. That's it. 2 more sections and it'll be over. 168, what is it? Let me tell you one thing. So the section 168 talks about resignation. Resignation is very simple. If director wishes, he'll resign by notifying company with resignation. As soon as the company receives a resignation notice, the company does 4 things. 4 things. First, the board will take his note, write it once. Second, board will publish it on their website. Third, board will include it in their report when it publishes next report on their website. Also, the board will intimate the ROC within 30 days. Which form will you use to intimate? The DIR 12. In which the director's appointment was made, right? The one in which you sent the consent, we will be sending your resignation in the same form in DIR 12. But if there's a reason, then provide the reason with that. But sometimes a director can directly go to ROC and give the reason by filing DIR 11. DIR 11 is optional. But the day you send the notice, right? Within 30 days from that date, you have to file DIR 11 to ROC. If you would like to file, then you can do so, okay? If someone's office was vacated, if someone's office becomes vacant, can you reappoint them? You can do. There's no provision in law for that. There's no disqualification. If your office becomes vacant since you didn't attend board meeting for 12 months, right after that, in the next general meeting, you can also be appointed. But why would they appoint you? Shareholders won't let you to be appointed. Come back. You have the option to file DIR 11. I showed you DIR 11 in class. You have to provide the reasons in it. Why did you leave? Now listen carefully. Here, to file the DIR 11, you need a DSC, which is a digital signature. What will this foreign director do? If there's a foreign director, he wants you to file what? DIR 11. So what will he do? If he intends, then he will first check if DIR 12 has been filed. If DIR 12 is filed, then he can delegate his authority to some other director, or by giving authority to any CA or CS on his behalf, he can get the DIR 11 filed. But when can he file it? By giving authority to someone. Only and only if DIR 12 has been filed. If there's a foreign director, so after DIR 12 is filed, he can delegate authority to someone else and get DIR 11 filed. If you submit your resignation in this way, tell me when this resignation will be effective. When? On the day your resignation was delivered, or the date that you mentioned in the notice, whichever is later. The delivery date or the date you mentioned in the notice, whichever is later. Now you tell me one thing, if the company refused to accept the resignation, then will it make any difference? No, not at all. The company's acceptance is not necessary. If the company refused to file with the ROC and did not file DIR 12, will the resignation impact? No, it will be effective on the same day. The day your notice was delivered to the company, or the date which you mentioned in the notice, whichever is later from these two, whichever is later. So this is the resignation provision. Post this, I mean here after resigning, let's say you were appointed for 5 years. You resigned after 3 years. Whatever mishap you did for the 3 years, you are responsible for it. I mean can't which starts with K. Whatever mishap you did, you are responsible for it. And you will remain responsible for it. Understood? Post this, we'll discuss section 169. Section 169 deals with removal of a director. How is the removal of a director done? Tell me. If you want to remove a director, a special notice will be sent to the company. Where does it say about the special notice? Section 115. Special notice. Just listen carefully to what I say. Special notice is mentioned in section 115. Who sends the special notice? Either that member who has 1% of the voting power, or the members who hold a paid up share capital of up to 5 lakh rupees. Either from these two send a notice. You know that the notice should be given at least 14 days before the meeting. But the maximum is 3 months before you can give the notice. You can't go beyond. Only within that time period you can send the notice. At least 14 days before you can send it. But you cannot send it before 3 months. During this period, you will send a notice to the company. So Mukesh Ambani, who is the director of Reliance Industries, you want to remove him. As soon as the company receives this notice, they will send it to Mukesh Ambani. They'll run, go to Mukesh Ambani, notice has arrived, it's time for you to leave now. Your friend has already left, now it's time for you to leave too. As soon as this notice arrives to Mukesh Ambani gets 2 rights. One right is on oral representation. Second is written representation. My throat got struck a little, I wasn't able to speak. As I stop, you guys start thinking. An oral representation and written representation. What is oral representation? Right to be heard at the meeting. He'll go to the meeting and tell his story. What is written representation? He'll write a letter. This written representation will be given to the company. And he will tell the company, You'll send a notice to the members, right? The notice you'll send, which is 7 days in advance. Just mention in the notice that I've given a written representation, and written representation is attached. And you'll attach and send my written representation, right? What will the company do? They'll try their best to send it. But if you are unable to send a written representation due to lack of time, you were unable to send written representation. So this written representation, what you'll do with it? You'll read out loud in the annual general meeting. Just by reading it out, the right to oral representation is not altered. Though it is an oral representation, it will be done. But if he used abusive language in his written representation to 1 or 2 directors, what will happen? So the aggrieved person, the one who is upset, they can go to tribunal and file an application. So this written representation, it is being abused. What did I say? It is being abused to secure the needless publicity for defamatory matters. So it's being abused to secure needless publicity. Needless publicity means you're forcefully getting into trouble for the need for defamatory matters. Law says it's being used to secure needless publicity. Then what will the tribunal do? Then the tribunal will give an order that your written representation won't be sent, won't send it, nor will we read it out loud. Not only that, but also the fee for submitting this application, that also needs to be reimbursed by you. I mean who? Mukesh Ambani has to reimburse. Will neither send your written representation, nor will read it out to you. And we will not read it to the shareholders also. And you will have to reimburse the fee. Then the written representation won't be sent. If you remove in this way, but when he is removed, that office is vacated. When an office gets vacant, fill it by 2 ways. Either write about the appointment in the special notice. If the appointment is mentioned, then make appointment according to that. If there's nothing written in it, so this removal will be considered as a vacancy under section 167. Under section 161 subsection 4, this removal will be considered as casual vacancy. If there's a casual vacancy, then the board of directors, if there's a casual vacancy, then the board of directors will fill that. If casual vacancy, so the board of directors will fill that. Did you understand? Did you understand, guys? If there's casual vacancy, board of directors will fill it if they wish. Always remember that 3 directors on the board can never be removed. Which 3 directors? One is 161 3 director, nominee director. Other one is the 163 director, proportional representation director. Then 242 director. 242 is the one that the tribunal appointed. He can never be removed. If all the company directors are removed simultaneously, in that case, either the promoters or the central government will take over. You understand? OMG. The biggest thing is, when the general meeting happens, in general meeting an OR for removal will be passed. OR will be passed. If an independent director who has been reappointed, if he has to be removed, right? You'll have to pass the SR. Not every independent director. That independent director who has been reappointed. To remove him, you will have to pass the SR. Did you get my point? Did you understand my point? This whole provision is covered. Make some time and read it. One more point. Due to your removal, you will not be deprived of your CFLO. Okay? If you are eligible for CFLO, compensation for loss of office, so you'll get that. We will read about it later. Another thing, guys. When you are removing someone, it is not mandatory to mention the reason for the removal. Where was it written? In the case of LIC versus Escort Limited. Where was it? In the case of LIC versus Escort Limited. Section 170 says, every company has to maintain the shareholdings of their managerial personnel and also the directors. How much shareholding is in cash? How much shareholding is in any subsidiary? It has to be maintained in a register. Where will you keep this register? You'll keep it in the registered office and maintain all the details in it. Whenever a new director or key managerial person joins, or any changes happen in the existing shareholding, what will you do in 30 days? You'll intimate the ROC. Whom will you intimate? Within 30 days. You'll intimate ROC. Later, what does 171 say? This registered office, right? What does section 171 say? This registered office, right? This register will be available for inspection by shareholders. When you'll inspect, you can either inspect it during the business hours or can inspect during AGM as well. You can also inspect it during AGM means that it actually means you can access this register during the AGM. You have to take register to the venue of the AGM and you can inspect it. You can take the extract, also request copies. Can get it delivered to your home for free. You can have it delivered for free. Section 172. If in this chapter, not in the act, but in this chapter, if we happen to miss writing penalty anywhere, then in this chapter, if we miss writing the term penalty anywhere, what will be the penalty? A separate penalty for company and for officer in default. It'll start at 50,000 rupees per day, which will be 500 rupees per day up to a maximum of 3 lakhs. But for your officers in default, the maximum would be 1 lakh rupees. Did you understand this? Did you understand or did you not understand, guys? That's it, guys. I hope you enjoyed the revision. I'll end the session now. I'll see you soon in the next revision. It will take some time. My schedule is a bit tight, but I'll continue to bring this kind of revision. Friends, don't forget to like the video. And also, don't forget to share this with your friends. And don't forget to recommend our batch to your juniors so that they don't drift off somewhere else. I'll meet you in the next video. Take care. This is CA. Shubham Singhal signing off. Bye, guys. Bye, Manan. Bye, Muskan. Bye, Meghna. Bye, Kaushal. Drishti, bye, Bhavin. Bye. Will you explain one thing? No, Bhavin, I cannot. You read it again. This was revision actually. I explained it. That's a big deal. MCQs are already prepared, Dipin. You can see them already. Okay, guys. No. Revision will be along with our classes. Videos are already uploaded. You can see more videos. Guys, take care. Bye. See you all.